really fired up for this LinkedIn Live. I'm here with Steve Williams, who's a top landlord attorney. Steve, can you hear me okay?
I hear you great. Thank you.
Fantastic. Yeah, and for those of you who have not seen one of my shows yet, this is Giant TV. We do this every Thursday at 1 o'clock California time. And my role is I build out companies and businesses. So I have several businesses I'm building out, and I have a marketing company, founder and president of a marketing company that helps others to build and stand out and brand. And so one of the companies that I build out is a law firm in Southern California, Barth Calderon, asset protection, estate planning, business planning. And we have a lot of property owner clients. And I'm fortunate enough to have alliances with other experts like Steve Williams here, who is the founder and partner with Frieden Williams, a landlord firm in the Bay Area, California. And so there's a lot going on with property owners today and just hot button issues. And if you own rental income property or you advise on property, this is going to be a great discussion I'm going to have with Steve. It's going to be a back and forth. We're going to get into all the hot button issues around property. And so with that, Steve, let's just jump right into it. If you can start giving us a little bit of background on what's going on, what we should know.
Sure. Well, specifically, first I'm going to focus on California because that's where I practice. In January of this year, there was a very broad and sweeping law that brought virtually all properties in California, with some exceptions, under rent and eviction control. So it was pretty sweeping because I practice in the Bay Area where there's been various forms of rent and eviction control locally for decades. And now what this law does is, it did in January, is it expanded it to, not quite as strict as it is here locally, but a version of rent and eviction control throughout the entire state with a few exceptions. So that was the big news at the beginning of the year. Then, of course, in March, we get hit, with the COVID-19 pandemic that has just, raised all sorts of issues and complications with landlord-tenant situations. And property owners are now, the laws have been changing literally daily for a while. It seemed like something new was coming either at the state level, at the local level, at the county level, at the federal level. There were different laws being passed. It seemed daily, and it was difficult to keep up with. And now, in an effort, hopefully, to try and synthesize some of these things, the state of California has passed its own law more recently. It went effective September 1st, known as the COVID Tenant Relief Act. And what that does is it brings basically a moratorium on certain types of evictions through a period of time, and that time is through March, through February, and it's actually through January for non-payment of rent cases. But I'll talk a little bit more about that in a minute. So this now broad law has said, okay, well, we're going to put a ban or restriction on evictions of basically any kind in California through a period of time into early next year. And then the CDC federally also issued its own laws saying, well, if your state doesn't have laws that are as broad or broader than these CDC laws, then these CDC laws, which also restrict evictions, will be in place. So if you're outside of California, you also have rent and eviction control, eviction controls right now. I don't recall specifically if it has a rent limitation as well, but certainly an eviction limitation at the federal level, which applies to all states that don't have their own laws in place. Now, California has its own law, which in my opinion is broader than the federal law, so this state law would apply. Of course, you may get some tenant advocates that disagree for certain components of different laws that may be more protective, and they might fight it. But in general, my understanding is that the new state law would control over the federal law in California. But then you also have to look to your local laws to see if there's some local laws that may still apply, notwithstanding the passage of the state law. Like, for instance, in San Francisco, there was a law that was in effect until actually October 1st that may have applied, which is now expired, so the state law applies. But San Francisco did pass another law that runs through March, prohibiting evictions of all kinds except non-payment of rent, that is broader than the more restrictive to landlords than the state law, which in my opinion does apply. So in general, here's what the laws prohibit. You generally cannot do an eviction of any kind in California unless it is related to either health and safety issues like violence, health and safety, where there's a threat of health and safety,
Right.
Or what's known as the Ellis Act, which is the landlord's right to just simply wash their hands and go out of the rental business.
Okay.
And that's in local jurisdictions is where that's more more prevalent. But generally, so the real limitation is really just health and safety. Now, there's two components. There's the general evictions, and then there's non-payment of rent evictions. This law also prohibits non-payment of rent evictions, so long as the tenant has been impacted somewhat by COVID-19. And
what does that mean? Impacted in what way?
Yeah, it's very broad, but financially, it's meant financially. Whether that means lost income or increased expenses. And the way it works is that the legislators have conveniently prepared a nice, declaration. I think it's a one-page declaration that a tenant can fill out. So they've done all the work for the tenant here.
Right.
Convenient. When I say convenient, I'm being sarcastic. It's convenient for the tenant. That if the tenant just simply fills out, just signs their name on this form, which says, I've been impacted, I've lost income, my costs have increased. So there's a whole list of things, but there's like a general catch-all that says, I've had increased expenses due to COVID-19. It's pretty broad. I mean,
Right.
My expenses have probably increased due to COVID-19. I bought just on hand sanitizer alone. So it's a pretty broad catch-all that I'm advising clients that expect your tenants will be able to honestly sign this declaration, return it to you, and you will not be able to evict them for non-payment of rent during this period of time. This period of time is from March 1st, 2020 through January 31st, 2021. So if your tenant has not paid rent during this time and returns that declaration to you, you can't evict them ever for not paying that rent.
Can you get the rent back later on after this period, or you just can't get any money for that whole period?
Yeah, it's a good question. So the law is broken down. I give talks I've given 2-hour talks on just this subject. So I'm going to break it down. There's 2 periods of time: March 1st to September to August 31st. September. So March 1st to August 31st is what's called the protected period. So that time, from that period, if they return that declaration to you, you will never be able to evict them for not paying that rent. However, the rent's not waived. You can still try to collect that rent from them. You just cannot do so in the form of an eviction. You can't displace them for not paying it. Instead, you file a court action against them. And part of the law, what it has done is it has expanded the jurisdiction of the small claims courts. So now a small claims court is unlimited in jurisdiction for the amount. It used to be $10,000 was the cap. You could not sue in small claims court for anything greater than $10,000. Now, so long as you're suing for just rent, you could sue for $1 million if that's what's outstanding. Now, this is residential. This law, this COVID Tenant Relief Act does not apply commercially. So this is just strictly residential. So there's an unlimited cap right now. So for this protected period, you could go, let's say the tenant didn't pay from March all the way through August. They return that declaration. You can then sue them in small claims court for 100% of the rent that was due during that time. Cannot evict them ever for that. Now, there's the second period of time, which is sort of an adjusted period of time from September 1st through January 31st. So in addition to that declaration that I just talked about, the tenant has to pay 25% of the rent to get eviction protection. So if the tenant pays 25% of the rent, then you can collect that additional 75% in small claims court. If the tenant does not pay the 25%, but let's say returns the declaration, you could evict them for not paying that 25%. You could file an unlawful detainer action.
So Steve, let me ask you a quick question here. Is if you're a landlord and you're in the scenario where your tenant, is having problems paying, before it escalates to, court battles, all that stuff, what would be your recommendation on how to amicably approach this scenario to avoid a hornet's nest?
Yeah.
Like what do you do up front? This is for anybody who owns rental property.
Yeah. So the way I've been handling this is, for the most part, is by reaching out to the tenant, and by letter, usually in writing, and some landlords will do it orally. Say, hey, look, tenant, I understand times are tough. This is going on throughout the entire world, and everyone's impacted, including me. I understand you're not paying. What is the reason you're not paying? Okay, related to COVID-19, you lost your job, whatever. So what can you pay? Can you pay something? So to really try to reasonably work something out with the tenant. Now, if you do end up working something out, depending on the jurisdiction, you need to be very careful with that workout, because like in my area in San Francisco, if you do, let's say you agree to accept, 50% of the rent, for instance, for a period of time, you potentially run the risk of permanently reducing the rent in San Francisco or in Oakland or in Berkeley. So in certain rent control jurisdictions, you do run a risk of potentially permanently reducing that base rent.
Why? Because you set a precedent or something, or?
Yeah. So in short, so like in San Francisco, for instance, they allow you. I say they, the rent board, and under the rent ordinance, allows you to temporarily reduce a rent so long as it's related to a personal tenant financial hardship. If it is not related to a tenant personal financial hardship, but instead some market factor, like, hey, rents have gone down across the board, so I'm going to temporarily reduce your rent. The way in San Francisco that the rent board has interpreted that is, if it's due to market circumstances, we're sorry, that's a permanent reduction. If it's related to something specific to the tenant, like I lost my job or I lost a co-tenant, I have to find a replacement tenant. So until I do, I need some help. In that personal situation, you can restore the rent, after a period of time.
Okay.
So you have to be very careful and consult with an attorney in your area to make sure if you do some sort of a temporary reduction that it doesn't become permanent. So there's always that potential risk. I have had clients who've also done permanent rent reductions because the market has declined. Let's say it's gone down 10% in your area, right, and the tenant is, maybe it's a good tenant. They say, well, look, I can rent this place across the street for cheaper, so I'm leaving. Well, I've had situations where the landlord will work with the tenant and okay, I'll reduce your rent 10% or 15% just to keep it, because right now it's not a renter's market. I mean, it is a renter's. It's not an owner's market to get your units filled. So I have clients who are just happy to have bodies and paying bodies in units. So there's a couple ways to handle it. And in response to your question is just approaching the tenant, finding out what the issue is, what the concern is, and seeing what the tenant can pay, and seeing if you can't at least get something in your pocket right now. And maybe if you work out amicably, then your tenant will be appreciative, and you'll have a good working relationship. And then when things clear up, you'll get things back on track. So there are different things you can do.
Right. Are you seeing, since we're in this kind of frothy period here, are you seeing more actions by tenants towards landlords, complaints? I mean, you and I talk often, and I hear back from you on some of the issues about, tenants suing for mold claim and all these things that crop up. Have you seen growth in that in this period?
I personally have not. I see so much of that anyways. It seems like it's pretty much just, business as usual in that capacity. So it is so easy for tenants to make habitability claims and file those types of lawsuits against landlords in rent control jurisdictions. And mold is a popular one, a very hot topic. And I do give talks on tenant lawsuits and those particular types of claims. I have not personally seen an uptick in those. Right. And luckily, I have not really seen personally a lot of tenants that appear to be just gaming the system and not paying rent now. I by and large, and I've talked to my clients about this, by and large, the ones, if they can pay, they're paying. They're not, I'm sure there's some outliers and there are a few exceptions, but the ones that aren't paying or can't pay the full amount, it seems that they truly have hit hard times. So even though the laws are very protective right now of tenants and virtually anyone could avoid paying rent right now, it seems like the ones that can are. And I'm sure there's nightmare stories and other stories out there, but I just haven't seen a real increase in tenants gaming the system and just simply not refusing to pay. Which I always tell clients, if you are aggressive with your tenants, they may dig their heels in and you may get nothing from them. In which case, the alternative by reaching out to them and trying to be understanding has had some positive effects. Yeah.
Well, in normal times, what are some of the hot issues that you are counseling your landlord clients on? I mean, I know you just had a big webinar that you did with a colleague of mine at the law firm, Brad Barth, and you both were talking to a bunch of property owners. What are some of the hot issues that you're focused on normally?
Yeah. So right now, it's the new state law that went into effect in January, which has somewhat been overshadowed because of COVID-19, which has kicked in all sorts of additional protections. But this state law thing was huge because, like I said, where I practice, it's always been the case. So for my clients, it's pretty much business as usual for most of my clients. But now I'm getting clients who are not in my specific typical demographic. So people who own properties out in the Central Valley of California or in the mountains or the foothills and the areas where there has been no hint of rent or eviction control ever, now has to deal with it. So that has really been the hot topic this year and leading up to this year. Another very hot topic was Proposition 21, which luckily was defeated in November on the ballot. And that's so significant because that particular challenge, whether that proposition was challenging, was a state law known as Costa-Hawkins, which is the main body of law that is preventing jurisdictions, rent control jurisdictions, from controlling several rents. And the most significant one is single-family homes. So single-family homes are generally exempt from rent control. That state law is what's keeping it exempt from rent control. Vacancy control, which is huge. So when a unit becomes vacant, you can charge market rent to the new tenant. Costa-Hawkins enables that. It allows that. And rent control jurisdictions cannot tinker with that. They cannot change that. It drives them crazy. And that's why they seek these laws to revise that, to allow them to control vacant units, which means that if your tenant moves out, let's say they've been there since 1999, they're paying 25% of the market rate. Well, guess what your new tenant, your incoming tenant would have to pay if that tenant moves out? Roughly the same rent.
Yeah.
If the local jurisdictions or rent jurisdictions can control vacant units. So Costa-Hawkins is that shield against that. And we had it in 2018 with Prop 11, I think it was. And it was now in 2020 with Prop 21, trying to eradicate that protection. So that's been huge, trying to, to save Costa-Hawkins. And there's going to be future challenges. Like I said, it drives tenant advocates crazy that they can't control those particular scenarios. And they want to get their hands into it and control everything. They want to control everything. At some point, they're probably going. That's just the way it's heading. Every law that comes out is favorable to tenants. You just don't get laws that are landlord friendly. You really don't, very rarely. So they're just picking and picking and picking and taking more. So we just have to pick our battles and try to defeat the proposed legislations that they're trying to pass.
When someone's getting into the buying property first time, or they're property owners, is there a particular level of advice you give somebody on best practices as a landlord, when you're getting into the business? Is it treating it like a business, things you really should be doing? What are some of the issues there?
Yeah, so one, do your due diligence. So if you are buying a property that's already tenant occupied, do your due diligence. Get as much information about the tenants and the terms of their tenancy as possible.
How do you do that? I mean, is that just
So you ask the current landlord for copies, of course, of the rental agreements, all rent increases, and that's particularly important in long-term rent control jurisdictions. And you're going to want that now statewide with the new laws to make sure that all the increases have been proper throughout the years. So you want to get that. You want to get any changes in terms of tenancy, any addenda or amendments to the rental agreement. And you also generally want to ask for what's called, a tenant questionnaire, or it's oftentimes referred to as an estoppel, where the current owner sends to the tenant a request for tenant information. So, hey, tenant, identify all these things. What are the names of all the current tenants? What's the current rent? What are the terms of your tenancy? So it's a laundry list of terms of tenancy. So then it's coming from the tenant directly. So hopefully, if they fill it out, they don't always fill it out, but you get that information, and then where the tenant's coming from and what issues they have or what claims they may have. So you go in with your eyes open, to get as much information as you can. And then two, study and familiarize yourself with the rent and eviction controls that are in place in your particular jurisdiction, whether it's a local or a statewide rent or eviction control. Now, if you're a new landlord and you're in addition to those things, let's say you're buying the property that's empty and you're going to be the one putting the tenant in possession. Again, do your due diligence by, making sure that you vet any prospective applicant thoroughly. I've seen so many cases where the landlord is just dazzled by the tenant who comes in with a cashier's check or cash, and look, I'm an investment banker. I've got all my money tied up over here. I've got a big deal going here, and they're dressed like a professional, and they fall for that. And the tenant gets in, and then guess what? The first month comes, they don't get the rent. I'm not saying it's a common thing, but it happens. It does happen.
So do background checks and so forth?
Yeah, so I asked the client, well, did you check their references? Did you check their current landlord? Did you do a credit check? Did you check their credit report and their source of income? Did you do all that? Well, no, because I was blinded by this dangling of cash or whatever it is. And that's when you get into trouble. It can still happen no matter how thorough your vetting is, but do your due diligence, it's a tongue twister, on at the very outset. And also, even before the due diligence, you have to make sure you comply with all fair housing laws, with your marketing and advertising and vetting of tenants. So there's a broad area of laws that protect against discrimination against a number of groups. And if you're not complying with that, then you could face a fair housing claim. So familiarize yourself with those laws and make sure you market and list and then vet and reject or accept someone based on their income, their qualifications, not based on any protected group.
And then when somebody gets in, so you've done all the upfront, you vet, they're in on an ongoing basis, best practices as a landlord are what? And where do you see things maybe go awry if you don't do them right?
Yeah. So, stay on top of the tenant, make sure the tenant is complying with the terms of the rental agreement. I just gave a talk yesterday and stressed the importance of enforcing the rental agreement. So let's say the tenant comes in and then they move in, they move a friend in, a subtenant, a roommate. They move a roommate in. And if they do that, and you're aware of that and don't do anything about it, you're going to be stuck with it. If you say the roommate moves in and you say, oh, whatever, and you get the rent for November and the rent for December, and then let's say next May the roommate turns out to be sort of a bad seed, and you say, well, you know what, your rental agreement says no subletting. You need to remove him. At that point, it's probably too late because you have accepted rent with knowledge of a breach of the rental agreement, and that is oftentimes equated to a waiver of the right to enforce that provision. So what I emphasized yesterday in a talk is, look, if you see something going on that is not in compliance with the rental agreement, unless you don't care, maybe it's not some material term that you don't care about, but if it's something that is important, do something about it now, or potentially forever hold your peace. Now that's one. Two, always respond to tenant complaints. So if the tenant says, hey, my sink isn't working, or the hot water isn't working, pretty common sense, get someone out there and take care of it and document it in writing. Because guess what? If you don't, then the tenant's version will, if something comes up in the future, is, well, I told them about this, and it wasn't for 6 months until they fixed it. Well, if the tenant calls in and complains about it on November 20th, you get someone out there to say November 23rd you get someone out there to fix it. Then you do a follow-up. Hey, look, on November 20th, you called and let me know about this issue. On November 23rd, I had someone out there to fix it. And it's been reported to me that it's repaired. If it has not, please let me know as soon as possible in writing. And let me know if there's anything else that is wrong or anything else that needs to be addressed. And that way the ball's in their court. You have a nice paper trail, shows the timeline, and that will come back to protect you if things go awry in the future. You can show, well, look how diligent I was here.
Yeah. No, great advice. What about as legalized marijuana, becoming, more prevalent everywhere? Is that a big deal, with the liability that can come along with that? Like, how does that work?
Yeah, so there's really two main, areas of law in California. Again, this is another hot topic that I do long talks on, where you've got two areas of law. One is and this has been in place now for, about 25 years, is the medical use. The other area, which has been in place now for, I think it just went into effect a year ago, I think in 2019, is the recreational use. So medical and recreational. You have to treat them differently. The medical use is going to be, governed, the way you treat it is going to be governed or overseen by fair housing laws. So just in general, fair housing laws require that landlords make accommodations for tenants with disabilities. So, and marijuana has been known to have medicinal effects. So someone with a disability may use marijuana to help alleviate the symptoms of that disability. So if the tenant says, hey, I have depression, I've got, chronic backache, whatever it is, and maybe they produce a doctor's note, and look, marijuana alleviates the symptoms and it helps treat me, then the landlord generally has to allow that. Not only use of it, but even growth of it, if you can believe that. So the
tenant, ask about that. They can grow it in the unit.
Grow it in their unit, yes. Up to 6 plants. Excuse me, up to 12 plants in California. Up to 12 plants they can grow for medicinal use. So there's not a lot you can do about that. Of course, they can't go around smoking it in common areas or growing it in common areas, but if they're using it discreetly within their unit, not much you can do about it. Recreationally, you have control over that. So if you have a lease provision that says, hey, no smoking at all in the unit of any kind, then you can enforce that against recreational use. The right to use it recreationally does not supersede your rental agreement. So if you have a lease contract that prohibits it, you can control it. Problem is, the issue I see is that, just like the dog, the comfort animal, someone brings a dog in, it's a pet, and the landlord says, hey, you have a no pet provision. And then the tenant says, oh, hold on a minute. Then they run out, and a week later they have a doctor's note. Well, so-and-so has, has anxiety, and having a comfort animal alleviates the symptoms of that anxiety. Well, guess what? Now you have to accommodate that because that's a fair housing issue. Same thing with marijuana. You call them on it recreationally, they then run out and get the doctor's note, and guess what? Now it's a medical issue and you have to treat it as fair housing. But again, until they do that, you can treat it recreation. Until they put you on notice that it is for a medical issue, you can treat it as a recreational issue. And if you have a contract that prohibits it, then you can attempt to enforce that.
Great. God, I was thinking my dog gives me anxiety when she has to go to the bathroom and she's whining for food.
I see my neighbor in his pajamas out with a puppy. He just got the puppy out at like 2 a.m, walking the dog in his pajamas. So yeah.
Question is, what are you doing up at 2 a.m. if you don't have a puppy?
I'm working for my clients, trying to get around these laws.
Oh yeah. Man, Steve, this is great information. I know that when our firms do a lot of work together and workshops and so forth, we talk a lot about liability and legal structures for the property. We're not going to get into that today, but certainly your expertise in managing a property properly gets into avoiding liability and avoiding, scraps with the tenant, which is, what we all want to do.
Right. That's how we our firms sort of, work together on that, is that I can help with these issues and counsel. Unfortunately, a lot of times clients come to me after the fact, after they've already, engaged in a certain practice. But I can counsel them on what to do and what not to do. And then, things like, additional measures that can be taken, such as structuring the property in a certain format, like in an LLC or some sort of a company with some sort of a protective shield, is just another measure, a way to protect yourself. So I always tell clients when like your question was, what can they do to try to, protect themselves against tenant claims? And I've given you a few examples. Another is, making sure you get the proper insurance as a landlord in place.
Right.
And then also consulting with, an asset protection firm like your firm to see, what you can do to shield that property and yourself personally, if and when a claim does occur. So there's certain things you can do. It's never 100% foolproof. You can just do as much as you can. The laws are so favorable to tenants, and in California, you can sue anyone for anything. It doesn't mean it's a viable lawsuit, but you can. And so the more protections you have, the better, and the better way you handle tenant, issues, the better. Yeah.
It's just at the law firm Barth Calderon. I know you've seen the same thing as rental property, great business to be in, but it does come with a liability footprint, and you've got to treat it like a business and just get buttoned up, protected, well organized. And, then, you have the better chance of avoiding conflict and some of these unforeseen things that might pop up.
Yeah. That's
Yeah.
right.
Steve, great talk. I've got to ask you, I always kind of leave this because it's interesting to me is, you work so hard and you're up at 2 a.m. servicing your clients. How do you do you get good cardio in? Are you able to get a good workout in a couple times a week?
I'm embarrassed to say you're putting me on the spot here. No, since COVID-19 hit, I've been pretty inactive. Now I'm chasing a couple of kids around the house, a 6-year-old and a 8-year-old who have so much pent up energy because they can't get out either. But other than that, I have not been able to get out and do the sort of exercise that I was doing before. But that needs to change, and that will change.
That will change. That will change. Steve, thanks so much. Always great to have you on, and I know we'll be talking again soon.
Sounds good. All right. Thanks, Paul.
All right.